Well, welcome back to Uncontested with Sean Lohman, a podcast about simplifying the complicated world of estate planning so that you can start protecting your family's legacy today. Please welcome your estate planning expert and host, Sean Lohman. How you doing, Mr. Sean?
I'm well. How are you doing, Joel?
I'm doing very well. Thanks for inviting me back on the show.
Yeah.
We have been going through just some high-level information on estate planning, what it is, what are some major building blocks of what estate planning is. And so last week we talked about specifically the will and the trust, a little bit of information about what each of those are and what each of those do. So give us a little bit of a recap, if you're willing, Mr. Sean. What is a will and what is a trust and what do they do?
Okay, so a will controls everything that's in your estate. And we've talked about what's in your estate. It's everything that you own in your name, basically. Your estate does not include things that you own with other people who are still alive, and it does not include anything that has a beneficiary designation. So, just anything that's in your name, your will controls who that goes to. A will, of course, goes through probate court. And if you don't have a will, you end up in probate court as well. And in our last episode, we talked about the pitfalls and the expenses and the time and everything involved in probate court. A trust is a document. It's a set of legal documents that provide ownership of your assets. So it never goes to probate court. You are the trustee of the trust, so you have full control over all of those assets. The assets can be sold, they can be taken out, they can be put in. It's just as if you own them today, but they never have to go to probate court. And when we talk about a trust, we're talking about a revocable living trust. Whenever I mention trust in this podcast series, most of the time I'm talking about a revocable living trust. I would state if I was talking about an irrevocable trust. But so when we talk about a will and a trust, everyone's going to need a will. Not everybody needs a trust, but we find that most people do. And it's going to save everybody that I recommend a trust for, it's going to save them money.
Yeah,
I wouldn't recommend it if it didn't.
Yeah, and time from what we've talked about as well.
A lot of time. Just keeping you out of probate court is very expensive.
Oh yeah, absolutely. And one thing we have talked about at great length on this show so far is you just don't want to be in probate court if you can avoid it in any way, shape, or form.
That's absolutely right. I just said keeping you out of probate court is very expensive. Keeping you out of probate court is very important. And we'll be talking about that. I'm sure in our future episodes, because that's what estate planning ultimately is about. It's about directing your assets. It's about making sure that your family's protected. And one way you protect your family is by saving and preserving your assets for them so that it's not going to attorney fees and it's not going to executor fees and it's not going to court fees. And you're not having them drag around court for 9 to 18 months. So, estate planning is about helping your family. And a great way to do that is by keeping them out of probate court.
Ain't that the truth? And we want to shout that from the rooftops. Come and see Sean, and he'll tell you how to make that happen.
Right.
Well, we wanted to kind of take a little bit more of a deep dive on what all estate planning looks like from just like a building blocks perspective. So yeah, please, we would encourage you to go back and listen to our last episode on the two main pillars, which would be the will and the trust. But today we're going to be taking a look specifically at just some of the other aspects, some of the other documents, some of the other parts of the plan that we all need to be thinking about. So start us off, Sean. What are just a few other things that we can think about when we're thinking about our estate plan?
So I call these ancillary documents because there are other documents that are involved in every estate plan we do. These are just included in every estate plan, but they're things that must be in place to help protect you during your lifetime. And that's really what this is about. Estate planning isn't just about protecting your assets for when you die.
Yeah.
A lot of estate planning involves making sure that you are taken care of while you're living, that your choices are followed. And so that's what the ancillary documents really do. So we have a will or a trust in place, but there are 4 primary ancillary documents that everyone really should have. That's the power of attorney. And we do a durable springing power of attorney, and I'll explain that. We do a healthcare power of attorney. We do a living will, and we do a HIPAA release, a health information release. So let's start with a durable power of attorney. A lot of people know what a power of attorney is. Powers of attorney have changed a lot over the years. When I started practicing law 28 years ago, they were 2-page documents. I mean, they would list, it would be like number 1, right underneath number 1, number 2. And it would say, they can control any bank account I have. Number 2, they can sell any real estate I have. Number 3. I mean, now the states are getting more and more particular about what they want in a power of attorney. So if somebody has a power of attorney that was entered or that was prepared 5 years ago, 10 years ago, 100% if it was over 10 years ago, it needs to be reviewed because chances are it doesn't even meet the requirements today.
Wow.
Oh, yeah. So you want a power of attorney that's very specific about what powers you are granting to somebody. And this is a financial power that you're granting to somebody. Now, we talk about having a trust, and we talk about owning your assets in a trust. And if you become incapacitated or disabled, there's an alternate trustee, and that person steps right in. And even if you're alive and just can't handle your own affairs, you've got somebody there to take care of things. Your bank account is in your trust. Your home is in your trust. Hopefully your business interest is in your trust. So that trustee can take care of all those things. The reason I explain that is because, well, then why do I need a power of attorney? Because there are financial things that are not in the trust. And those are the beneficiary designated assets. So you've got life insurance and you've got retirement plans. Those are never owned by your revocable living trust. Those are owned by you personally. But when you die, your beneficiary designation form says who they go to. So if you're incapacitated or disabled and your alternate trustee is operating your home, paying your bills, doing things like that, you need someone who can make investment decisions for your retirement accounts, who can make decisions regarding your life insurance and things like that. And that's where your power of attorney comes in. We make it durable, so it's called a durable power of attorney because that means it extends beyond your disability. So if it is not a durable power of attorney, or if it doesn't have the word durability in the text of the document, when you become disabled or incapacitated, that power of attorney is no longer any good.
Really?
And there's a lot of those floating around out there. And banks are really smart. Closing attorneys, real estate agents, they're all really, really smart. And they know whether that power of attorney is durable or not. And they will not let you use that power of attorney if the word durability is not in there or if it's not a durable power of attorney.
That's really interesting. Why is that, if I may ask that dangerous question?
Because when I give as the grantor somebody my power of attorney, and I name them what we call my attorney in fact or my agent, and I am of sound mind, I need to state that I recognize that this document will go beyond my disability or my incapacity. It is going to be a durable power of attorney, because if it's not, then I don't have the power to revoke it. So when I state that it's durable, I am giving up that power to revoke beyond my disability. If it doesn't state that it's durable, then once you become disabled, then it's no good, because we don't know whether you would have wanted that person to continue, because you haven't specifically given up that power to revoke that document. And it's a powerful document. A durable power of attorney is a very powerful document. We make sure that people think about who they're going to name, because you want to make sure that it is a trusted family member, a trusted advisor, somebody who you absolutely trust to do the right thing, because they do have a significant amount of power. And then most of the time, when somebody, again, is within that age range of 18 and mid-70s or older, as long as the person is relatively healthy, it looks like they're going to be okay, we make it a springing durable power of attorney. So we add another word to that, the word springing. What does that mean? It means that the power of attorney does not spring into effect until a spouse and a physician certify the disability of the individual. So if I name my oldest son, Connor, as my power of attorney, which I've done, in my springing power of attorney, he can't go to the bank and withdraw money. He can't go and hire somebody to sell my house. Why? Because it's not in effect until someone who I've designated, whether it's a spouse or someone else, someone close to me has certified my disability, and my treating physician has also certified my disability. They've both signed off on it. They both attached those documents to the power of attorney. And the power of attorney itself says this document does not go into force or effect unless there are these certifications attached to it.
Do you unfortunately see a lot of people trying to take advantage of the power of attorney?
100%. Oh, absolutely. People try to take advantage of a power of attorney. So the springing power of attorney makes people feel really good.
Yeah.
Because, it used to be, again, back when I started practicing 28 years ago, we would do a power of attorney for people and they would say, so my son or my spouse or my brother who I've named, they could go do anything they want with this document right now. And the answer is yes.
Wow.
If you go out of town, they could sell your house. I mean, because you gave them the power to do that. So this really protects you.
Yeah.
And it allows it not to go into effect until you've hit that point of incapacity or inability. And because it's durable, it will then last until you die. A power of attorney terminates as of the date of death. In fact, all of these ancillary documents terminate at the date of death. The only one that does not is a trust. And that's why it continues on and never has to go to probate court.
That's awesome.
So the second document that's really important is a healthcare power of attorney. So a healthcare power of attorney is not a living will. A living will deals with end-of-life decisions, and that's one of the ancillary documents. But a healthcare power of attorney does everything up to the end-of-life decisions. So if you lose incapacity and you've named your wife as your healthcare power of attorney, that allows her to choose your doctor for you. It allows her to choose a long-term care facility for you or a physical therapist for you or the type of treatment that you might need. It allows the person to make decisions regarding hospice care. So, we think, well, I'm married, I don't need that anyway, or I've got children, they'll just listen to them. A spouse is not automatically determined to have the other spouse's best interests at heart.
Really? Wow.
And so, to name that person that you want making those decisions in your life and then naming an alternate in case something happens to that person is really important. Without that in place, where do you end up? Probate court. All roads lead back to probate court. So if you do not have a healthcare power of attorney in place and somebody needs to make these decisions and needs to be named guardian over your person, you go to probate court and you petition probate court for that.
Wow. And I'm sure that's, again, costly, takes a lot of time. Those are things that you
it's
shouldn't
money,
have to worry
it's
about.
Time, and you can have people fighting over who's going to be your guardian. I mean, somebody that's in their early 30s and married, your parents could say, well, look, he is in a state right now that he might be in for a long time. Spouse may end up wanting to go get remarried or something like that. Name us as his guardian. Hell, we were his guardian for the first 20 years of his life, practically. We might as well be his guardian for the rest of his life. Spouse is in there arguing, no, this isn't what he would have wanted. So you get people fighting, and then you have a stranger, a judge, to make that decision. So healthcare power of attorney is very important to have. A living will is it's a much shorter document, but it's the most powerful document probably that we do. This is an end-of-life document. And, people think, God, I don't even want to think about that. But it is so desperately important that people do think about it. And this is really the one where, spouse may be standing there saying, make this call. I'm making this call,
Yeah.
and the doctor may think, God, that maybe is not in the patient's best interest. Should I be listening to the spouse? Does the spouse have the incapacitated spouse's best interest at heart? This is a tough one if you don't have it in place. So overall, what is a living will? You're naming a healthcare surrogate to make a decision on your behalf. If that healthcare surrogate is not available, then you can name another one, an alternate, or you can name two alternates. So you can name a spouse, and then you can name your parents as the alternate. And you can say that they must act together or they must act individually. There's a lot of different things that you can do with this. What are they being asked to do? You have to make decisions regarding artificial life support or no artificial life support, or the administration of artificial food and hydration and the withdrawal of artificial food and hydration. Those are the biggies. Those are the big calls. What are we going to do with that? Back a long time ago, and a lot of people listening to this podcast may have done this back in the day. It used to be everybody that came in said, I don't want to be on life support. If it comes to the point that I have to be on life support, turn it off. I don't want to be on life support. Well, what happened to those people during COVID? They died. They died because they had a living will in place. They were incapacitated, and their living will said, no artificial life support. And the doctors said, yes, we acknowledge that if they were on life support for 2 weeks, 3 weeks, maybe 4 weeks, we could possibly get them out of this.
Wow.
But we are directed by way of this living will to not administer artificial life support. And so those people
It's not
died.
situational. Wow.
It's not situational. That is a direct order. So what most people are doing today, and what I've always, if people were unsure and asked me what I thought, I've always said, you've named a healthcare surrogate. You can state in your living will that the healthcare surrogate should do what they feel is in my best interest at the time, but I do not direct the withholding or administering of life support. I do not direct the withholding or administration of artificial food and hydration. I leave it up to my healthcare surrogate to make that decision for me. An example, back in the 1990s was a couple, and the young lady's name was Terry Schiavo. And I don't know if you heard about Terry Schiavo or not, but back in the 90s, this was a huge case out of Florida, and Terry Schiavo had a cardiac event that led to her being in a persistent vegetative state. Her husband said Terry would have wanted to be allowed to die.
Yeah.
She would have wanted the withdrawal of artificial food and hydration, and she would have wanted to be able to die and be out of this persistent vegetative state. Her parents said, oh no, she was raised in a particular religion. She never would have wanted to have had that withdrawn. She would have wanted to live. And so began almost a 10-year fight over who was going to make a decision with Terry Schiavo. Terry didn't sign a 3-page document called a living will. Had she designated her husband or her mom and dad or whoever she wanted to be her healthcare surrogate, then this never would have been an issue. This case went to the Supreme Court twice, United States Supreme Court twice. Wow. Congress got involved. President George H.W. Bush got involved. The Florida legislature got involved. Laws were passed. Things were done. And finally, the Supreme Court made the ultimate decision, and Terry Schiavo was allowed to pass away. And her husband was determined to be her healthcare surrogate, and he was able to make those decisions. But imagine that cost. And imagine that fight just because a living will was not issued.
So let me ask you, did that case set a precedence for the spouse usually being given that right if in the event that there hasn't been a living will?
No, it didn't. And that's good. You don't want a precedent. It has to be situational. Let's say that I visited a divorce attorney and I was thinking about getting a divorce, and something happened to my spouse, and there's a $500,000 life insurance policy there. And the doctor says, what do you want to do? And I say,
See
what do you think? Where's the plug? I'll pull it. So, that's, and so, it's situational. You file the petition with the court, but then the parents know that there was discussion of divorce, and you get people who knew that there were discussions of divorce going on, and the judge says, no, we're not going to appoint you as a healthcare surrogate. And the court can appoint somebody completely independent. The court could appoint a parent. The court could appoint anybody. But again, there's money, there's time involved in all of that.
Yeah. Wow.
So in our documents, by the way, we do have candid conversations with our clients. Do you want to put in the document that if you become separated, or if somebody files for divorce, do you want us to make provisions for that? And typically we'll put, if the parties, or if I am separated from my spouse, or if divorce has been filed, my spouse is deemed to have predeceased me, which means that the spouse cannot, even though the spouse was named as a healthcare surrogate, either in the living will or the power of attorney or the healthcare power of attorney, the spouse can't be considered. It goes on to the alternate. So those provisions, we do build those in just to be safe.
Oh, yeah.
For the client. And then the last document that we prepare is a HIPAA release. A HIPAA release, a lot of people know the word HIPAA because every time you go into a hospital, every time you go into a doctor's office, you have to sign a HIPAA release. Why is that? For insurance purposes. Because when they file for insurance billing, or when they send your bill over to the insurance company typically wants to see the record so they can see what you were there for.
Yeah.
And so you sign a HIPAA release. Well, it's really important to have a HIPAA release signed for the people that you love, so that if you end up in the hospital, somebody can talk to the doctor without the doctor saying, hey, I don't know who I can talk to. I don't know who I can't talk to. If you have a HIPAA release on your phone that your loved one has signed, saying, here's the HIPAA release, a copy of a HIPAA release is perfectly valid. There's my name on the HIPAA release. The doctor and the nurses will readily talk to you. Tragic thing that happened to us, my daughter, Kennedy, she was a swimmer at the University of Texas. And one day I get a call from my ex-wife, and she says, my God, Kennedy fell this morning. She had hit her jaw on a bathtub. She fractured her jaw. She knocked a tooth out. She broke her nose. She lacerated her chin. She couldn't talk, and she was under medication at the emergency room. And all we knew is we were scrambling to get tickets to get out to Austin so we could find out what was going on with her daughter. But at the same time, we were trying to call the hospital, and the hospital could tell us nothing.
Wow.
Zero. Because what happens at midnight on your 18th birthday? No, it's like a shield comes down and nobody can find out anything about their children. Even though you're still paying their bills, all of that sort of stuff. You can't find out anything. So we had to go to Austin, talking to the coach, trying to talk to her friends who were going over to the hospital to find out from them, what did she look like? What was going on? Because they would not give us any information over the telephone. Had we had a HIPAA release signed, permitting us to talk to her doctors, then we would have been able to just either text it to a nurse, email it, fax it, whatever, from our phones directly to the hospital, and they would have been able to talk to us and communicate with us as we traveled there to be with our daughter. But, it was a terrible situation. And because of that, we do a lot of living wills and HIPAA releases for kids that are going off to college. So if we do a plan for somebody, we will ask them, do you have any children that are over the age of 18? Many of them do. And we ask, if we tell them, if you would like for them to do a living will and a HIPAA release, we'll do it for free. We don't charge extra. By the way, we don't charge extra for any of these documents. These are all included in our plans.
That's awesome.
But we will also do it for their children. And I do it for people's adult children as well, so that they have that peace of mind of knowing that they can talk to their, that they can talk to their kids, doctors if they're in the hospital, and that there is somebody designated to make end-of-life decisions to keep the family out of court and from fighting.
Yeah.
And that's
Wow.
desperately important. And I think that it serves people so well. And going back to how we charge for this, I think that there's the vast majority of attorneys out there, they're sort of a la carte.
Yeah,
And
kind of an add-on
they'll
kind of
say,
service.
well, this is what you charge. We charge you for a trust. This is what we charge you for a will. And then if you want a power of attorney, it's this much. If you want a healthcare power of attorney, you're going to add that on for this much. And it's like picking from a menu. Or they bill you hourly for these things, and we don't. We do not. Our fees are flat fees. They are set. We don't bill by the hour. Our clients can call us as much as they want during this process. We meet with them as many times as they want. We go into people's homes, and we sit down with them. We sit down with their families. We educate their kids on what's going on sometimes if they want us to. But all of these documents are included. It's not even a question. We are going to get these documents in place because you may not want to spend a couple $100 to do a HIPAA release. Well, we're not going to charge you that. We're just going to do it. And it is included in all of this.
Yeah, and that speaks volumes about just you, Sean, and your care for people, which is really apparent.
I appreciate that.
Yeah, man. Well, this has been really informative. I think I'm going to come talk to you, Sean. Yeah, this is one of those weird positions where I get to be in as the co-host, to being like, man, there's a few things in here that I haven't thought of, for sure, man. And with me and having 2 young children, I think these are just practical things that people need to think about today. So as I usually ask, as we're finishing off the episodes, what's just a first practical step that people can take to either learning more about this information or just taking the first steps to get these documents filled out for them?
The information, I go into sort of the same information I just talked about on my webinar. The webinar is 23 minutes long. If you link to the webinar, you can watch and learn a little bit more about the will and trust aspect, which I spoke about in our last podcast, but you can learn more about that in the webinar. I do talk about these documents in the webinar, and you can link straight from the webinar to schedule an appointment. If you attend the webinar, you do get money off of any plan that you decide to do. You can also just go straight to my website and you can click the Schedule Now button and just sign up for a family wealth planning session. There is a little bit of homework that you turn in before meeting with me, but if you turn it in, you get the family wealth planning session for free, which is 2 hours. I set aside 2 hours of my time. I walk through everything with you, and it's invaluable. Whether you do a plan or not, that's fine. It really is fine. I just want to educate you on what will happen should something happen to you today based upon your current plan, or if you have no plan in place. And if we can help you make changes to that would make you feel better, that would make you live a little bit easier and more comfortable, then we'll do that. We'll talk about what we can do to help.
That sounds great. Well, thank you so much, Sean, for your practical and just wise insights on all these things. And thank you very much for listening to Uncontested with Sean Lohman. We're always looking for new topics and questions to address. So if you do have any questions, please reach out so that you can continue to simplify the complicated world of estate planning for you and your family. All of our social links and the links to the website where you can learn more about Sean, his webinar, and what he does will be in the show notes of this episode. And please join us again next time for more great conversations and practical insights into the world of estate planning. Thanks so much for listening.